question is of a technical nature and you don't really understand it, don't answer it. Defer to your advisors. And that I find that the most likely area of questioning in this regard is regarding the valuation. How is the investigation closed? The ideal result of an investigation is a letter from the DOL saying we found no violations were detected, or the violations were so de minimis that no action is warranted. This is not unusual, but more likely they will find something. If there are problems identified in the course of the investigation, they may issue a voluntary compliance letter, which will state their findings and may include proposals. Very often they will not provide proposals for correction. They will simply tell you the problems that they have found, and if you ask them for suggestions, they may respond that that it's not their policy to solve your problems, that is up to you, but they will review your proposals for solving the problems and let you know whether or not they approve of them. The plan fiduciaries must respond to a voluntary compliance letter within 10 days, and as discussed before, extensions are routinely granted. The response may include disagreements with the findings, disagreements with conclusions of fact or law, and proposals for correction. Sometimes instead of a VC letter, a voluntary corrections letter, the DOL will state their findings and invite you to discuss how they may be addressed. And with more complex problems, this is more typical. In response to the earlier question about whether they ask for specific people to participate in a meeting, this is where you're likely to get a request that says, we want to meet with the company, the trustee, the trustee's financial advisor, and of course, counsel for any or all of those parties are also invited to participate. Negotiations may follow upon the response to a VC letter or following a meeting with the DOL. If the problems are complex, ESOP counsel, ESOP record keepers, the trustee's financial advisor, all may be involved in these negotiations. The Department of Labor Office of the Solicitor may also be involved. The solicitor is the attorney who acts on behalf of the DOL. The process for resolving a dispute is that they first will send you this VC letter, give you an opportunity to respond, meet with you. If you're unable to reach a resolution, they may refer the matter to the solicitor's office for litigation. If that happens, the solicitor may or may not pursue litigation. It's a separate decision by the solicitor's office. So the solicitor's office being involved from the very start doesn't necessarily mean that this is going to go to litigation, but it does mean generally, I should say in my experience, this is not a matter of DOL policy, but in my experience it means that they have found substantial problems and they expect that it may go to litigation. As a result of the negotiations, you may be able to arrive at a settlement agreement. If a settlement agreement is not reached, the DOL investigator may refer the matter to the DOL solicitor for litigation. If the settlement agreement is reached, the DOL may oversee performance of the settlement agreement. Sometimes these agreements take a significant amount of time to implement. Or they may condition the closing of the investigation on oversight of the agreement by an institutional trustee, subject to the DOL's satisfaction. I consider that an excellent resolution. If you can reach an agreement and have the DOL delegate the responsibility for implementing the agreement to professionals hired by the company, that's a great accomplishment and an indication that the matter will be resolved finally and completely. We have a question: how do you know if the matter has been referred to the DOL solicitor? Do you receive notice of litigation being started or a subpoena? There's both an informal process in which the threat to refer it to the solicitor's office becomes a indication that it has been referred. During the course of discussions and negotiations with the investigator, they may say to you, if this is not resolved, we're going to refer this to the solicitor's office. At some point, they may say, if you have 2 weeks before we refer this to the solicitor's office. You have 1 week. You may get a final call that says, has there been any further movement before we refer this to the solicitor's office? In my experience, which is a significant number of these investigations, I have yet to be involved in an investigation which is actually referred to the solicitor's office. I do have a couple going on right now in which the threat is very real and substantial, and in which I've spoken to the solicitor's office, who has said in more than one case, just because they refer something to us doesn't mean we're going to litigate it. So even if it does get referred, that is not necessarily an indication that there will be litigation. Of course, once litigation is commenced, you're under the Federal Rules of Civil Procedure, and you will receive notice of the litigation being commenced against you. Once the problems are resolved by negotiation and agreement, if that happens, the DOL will issue a closing letter, corrective action taken. And again, that's a good result. Civil penalties may be assessed. 502L is a code section of ERISA, imposes a mandatory penalty equal to 20% of the applicable recovery amount. Waiver may be granted upon showing of good faith and financial or other hardship. It's not an or, but you must have both an error made in good faith and the imposition of hardship. In my experience, again, the DOL is not very favorably inclined to waiving this 502L penalty when there's a settlement with the DOL. The good news is that if the DOL is overseeing a negotiation between the company or the sellers, depending on the nature of the problem, and the trustee, and the matter is resolved between the trustee and the company rather than between the DOL and the company, that doesn't come under the strict terms of 502L, and you may avoid the penalty by operating in that manner. Finally, the DOL may refer the matter to the Internal Revenue Service if they determine that excise taxes are due, which is the case in the event that a prohibited transaction has occurred. The applicable recovery amount, we have a question, what is the applicable recovery amount? Part of the DOL's letter after completion of its investigation, the voluntary correction letter will state that, for example, if the ESOP paid $10 million for the stock and the DOL determined that the fair market value of the stock was $8 million, the applicable recovery amount would be the $2 million excess purchase price because by paying more than $8 million, the plan engaged in a prohibited transaction with the seller by paying greater than the fair market value. So in that case, it would be a $2 million applicable recovery amount and then a 20% penalty, which would add $400,000 to that amount. There are, in broad terms, there are errors in transactions and documents in record keeping that occur in good faith and others that are not necessarily in good faith. The DOL is much more inclined to favorably resolve good faith errors, whether it's in the form of documents or in record keeping or in transaction structure, than they are when they feel that somebody has deliberately harmed the plan and plan participants. The first case study that I'd like to take a look at is release of suspense account shares and other record-keeping issues. The rules here are that ESOP record-keeping and accounting must be consistent with the law, ERISA, with the ESOP plan documents, and with the transaction documents. When dividends are used to pay down debt on leveraged shares, and this is one particular part of the law, the number of shares released from the suspense account must have a value not less than the value of the dividend. So in other words, if the ESOP trust receives dividends rather than contributions to repay debt, the shares released from suspense must equal the amount of the dividends. That seems like an easy rule to comply with, but if the value of stock has declined sharply, it's possible that the cash amount of the dividend could be greater than the value of the shares held in suspense. So let's look at some of the common problems that occur here. Calculation of interest based on a 360-day rather than 365-day year, and this is just a matter of complying with your transaction documents. Use of the wrong formula. Current principal. This is talking about how many shares get released upon receipt by the trust of a dividend or contribution. There are two formulas that can be used: the current principal of the loan divided by the total remaining principal of the loan, or the current amount of principal and interest due on the loan divided by the total remaining principal and interest under the loan. If the loan is greater than 10 years, you must use the principal and interest over principal and interest formula. But if it's less than 10 years, you still have a loan document that specifies one formula or the other, and you have to follow what your loan documents say. And the third example is the one that I mentioned a moment ago, that if the value of suspense account shares has declined, the number of shares that needs to be allocated for the share value to equal the amount of the dividend will be more than the proportionate amount of debt that the dividend can repay. As a result of this, all of the shares may be allocated before the debt is completely paid off. Solution: if there have been miscalculations, the miscalculation should be corrected, and the annual record keeping should be redone. Hopefully, this will be caught soon enough and you don't have to go back more than a year or two, but for whatever period there have been mistakes, you have to go back and correct them. If excess shares have been released and paid out to participants, you may have paid out too much money from the trust, and in that case, the company has to make restitution to the trust. The more difficult problem is the one to which I alluded a moment ago, that declining share value can be dealt with by simply releasing additional shares from the suspense account. However, this works in the short run, but in the long run, eventually all the shares being released from suspense before the loan is fully paid. There is no perfect solution to this. The people who drafted the law didn't understand the problem they were creating. But the better solution is for the company to make an additional contribution to fix the shortfall. The problem with this is that sometimes when share value is depressed, it's because the company is having a rough time, and making additional contributions may be difficult. One way of dealing with that is to contribute additional shares. That has its own complexities. As I said, no solution is perfect for this problem. The next case study, and this is probably the most frequent issue raised by DOL investigations, and that is default or collateral language in the ESOP loan documents. The rule is that exempt loans cannot provide for any payment by the ESOP other than the amount of the actual defaulted loan payment in the event of a default. They also cannot provide for any collateral or security interest in plan assets other than the shares that were acquired with the loan. And as the loan is repaid, shares must be released from the pledge, and the certificate from the released shares should be delivered to the trustee. This results in problems when, in an ESOP transaction, commercial loan documents are the template for the loan transaction documents. And the commercial loan documents include provisions that are perfectly appropriate and normal. In fact, it would probably be inappropriate not to have them in a commercial loan. And that is that if the borrower defaults, the entire loan amount comes due, and the borrower has pledged all of its assets as collateral, and all of those assets may be seized to satisfy the loan obligation. Those provisions violate the exempt loan rules, and if you have a loan document that says that, the DOL will reach the conclusion that you've entered into a prohibited transaction. The solution is to amend the loan documents. Now, you will see loan documents that have all of these lengthy commercial loan provisions that may run 2 or 3 pages, all the remedies that are available, and what constitutes a default and the remedies upon default. And then at the end, there's one little line that says, notwithstanding anything in this section, no provision of this loan agreement shall be construed in a manner that would violate ERISA. Now, that is probably enforceable in court, but the DOL takes the position that this does not save you from having to amend the loan documents. And it's such a simple solution, we've never tested with the DOL whether they're right on that. If you have loan documents that say acceleration on default, or the borrower, which is the ESOP, shall pay the lender's attorney fees, shall pay a penalty on default, shall pay an increased interest rate, you just amend the loan documents and take those provisions out. Next case study deals with misuse of company funds. When part of a company or all of a company is owned by an ESOP, executives and officers, shareholders or former shareholders cannot use the company's assets to pay their personal expenses. They cannot provide themselves excess compensation or bonuses. They cannot engage in transactions with related entities that involve a cost to the company greater than fair market value. Some business owners who've run businesses for years or decades or even generations often treat the company as their own personal pocketbook. These business owners may continue to do so after selling shares to the ESOP. Examples of this that we've seen include that S corporations pay some or all of their net income, that is income after paying reasonable compensation, as bonuses to their employee shareholders, but not including the ESOP, which is a shareholder, instead of paying shareholder distributions that do include the ESOP. We've seen expensive cars, vacation homes, salaries to non-working spouses, and benefits paid for by the company. And in really extreme cases, we've seen crazy things like investments in foreign, unrelated, non-operating assets purchased by the company, all without any recognition of the ESOP's interest. Now, certainly that last category is the most extreme. The good news here is that even in that extreme case, we worked through a settlement with the Department of Labor where we were able to solve the problem and not have any kind of penalties assessed. More recently, and this is the distinction I mentioned earlier between good faith errors and perhaps not good faith errors, more recently the DOL has focused on matters like compensation of executives, arguing that if the ESOP owns a portion of the company, especially when it's all of the company, and executives receive compensation from the company, that compensation is coming out of the pockets of the ESOP and the plan participants and should not exceed reasonable market compensation. The solution at the time of the transaction, and this is really important, include the future compensation and the other payments to the shareholders in the expense projections that are being considered by the trustee's financial advisor in determining what is fair market value. And as anyone who's been through one of these transactions knows, a huge element of fair market value is the company's net earnings. So if you're paying $100,000 to an executive, that's going to result in a higher share value than if you're paying $500,000 to that same executive, because the trustee's financial advisor is going to consider that amount going forward as part of the projections, and that has a big impact on value. So make sure that the payments to your executives, to your shareholders, to your former shareholders, are all part of the financial projections that go into determining value. After the transaction, make sure that you operate consistently with those projections. And as a matter of corporate governance, before a DOL investigation is commenced, have a board compensation committee and audit committee that review and approve any payments to the current or former shareholders and to the senior executives, so that you know, both from a substantive point of view, that what you're paying is market compensation, and from a procedural point of view, that you've fulfilled your fiduciary duties as a board or as a trustee or whatever role you're carrying to make sure that you're serving the constituencies to whom you owe those duties. And that we have several good webcasts available for you on our website that go into the issues of corporate governance in greater detail. If a problem does exist, figure out the cost to the company of any inappropriate use of company assets. You've got to add interest to those amounts for the lost time value of the money. And then you have to calculate the ESOP's pro rata share of these costs. So of course, if the ESOP owns 100%, that's very easy. Whatever percent the ESOP owns reduces the amount of plan loss relative to the amount of excess compensation or excess expense, whatever it may be. However, it also increases the amount that has to be paid to correct it. What I mean by that is, if take an example where the ESOP owns 1/3 of the company. If the company paid, let's say, $1 million of excess compensation, the amount of the plan loss is only 1/3 of that $1 million. But in order to correct that plan loss, if a payment was to be made by the company, the ESOP would in effect be paying 1/3 of the corrective amount. So you have to increase it to reflect that circular payment and to protect the ESOP from, in effect, paying its own restitution. This restitution can come in a variety of forms. It may simply be a cash payment by the company to the ESOP. It may be a commitment to make contributions to a 401k plan or other defined contribution plan in the future. It may be a redemption of stock from the ESOP. If the ESOP really isn't working out, if this company just isn't really meant to be an ESOP because of the management or other shareholder values and attitudes, perhaps the best thing to do is get rid of the ESOP, redeem the shares owned by the ESOP, but you have to do that at a value that reflects the loss to the ESOP, so you have a premium to compensate for prior errors. Another way to do it is to adjust the number of shares owned by the ESOP, so that if a seller sold 30% and has subsequently received unreasonable compensation, a solution may be for that same seller to, in one form or another, provide an additional 10% of the equity of the company to the ESOP. Now, I say in one form or another because the process for doing that is complex and can vary greatly. You could do it through a recapitalization of the shares, providing special dividend rights to the ESOP. You could do it by issuing additional shares to the ESOP. You could do it by having shares contributed to the company. And each one of these is going to have different impacts upon the current, the active participants in the plan, the inactive participants in the plan, the company, the seller. So there's a lot of details to consider. The point is just that this solution can be structured carefully and creatively to accomplish the goals and to solve the problems without putting undue burdens or insurmountable expenses on any party. The next case study is sort of a special case example of the prior one, and so I've labeled it Case Study 3.1 because it really is about use of company funds, and that issue is indemnification of ESOP fiduciaries. What we have seen is a DOL investigation in which the DOL determines that the plan trustee engaged in a prohibited transaction or failed to fulfill its fiduciary duties, and the plan trustee turns to the company and says, well, look at my engagement letter that you signed way back when. It says that you will indemnify me for any liability that occurs as a result of this transaction. Well, the DOL has taken the position both in investigation negotiations and in some court proceedings that provision is unenforceable, and that the fact that you entered into that agreement at all is a violation of ERISA. They say that it's unenforceable because ERISA imposes fiduciary duties on plan fiduciaries. They say that you can't agree to reduce those obligations. Now, we have argued, and we're in the midst of these arguments right now, so I can't tell you the outcome, though if you tune in again next year, I hope that I will be able to. We have argued that it doesn't eliminate the obligation, it simply shifts it to another party, and that shifting of obligations is very common in commercial transactions. It happens all the time. It is essential to the commercial system working, and that's how deals are done. that is taken into account in determining fair market value. Their response thus far has been, don't bore me with those rational arguments. The company cannot indemnify the ESOP. Not really sure how this is all going to play out. If the company has agreed to do it, I think that the position that we are taking in these investigations is that it's a valid provision, that it was entered into as part of the engagement of the fiduciary, as an inducement and as part of the compensation for the fiduciary to perform the services that it did perform. The part of the argument that I think is strongest from the DOL point of view is that that it's circular, that if the company is owned 30% by the ESOP and the company reimburses or indemnifies the fiduciary for a liability, it's not that the indemnification itself is illegal as much as that the indemnification is circular. It essentially eliminates the protection to the plan participants that ERISA is designed to provide. Because if the company is owned by the ESOP and the cost of indemnifying comes from the company, in effect the cost is coming out of the ESOP, at least to the extent that the ESOP is the shareholder. So if the ESOP owns 30% of the amount indemnified is coming out of the ESOP. If the ESOP owns 100%, then the ESOP is not being protected at all by this indemnification. The solution is to obtain fiduciary liability insurance from an outside insurer. Now, this gets into a technical area of insurance law, specifically that most insurance policies today are what they call claims-made policies, which provide indemnification for liabilities based upon when a claim is made. So if you have insurance on the date of the closing and 2 or 3 or 4 years later the DOL commences an investigation, determines that there was a plan loss and assesses liability against a plan trustee, that policy better still be in effect on that day. And that's therefore what we call a tail policy. The statute of limitations, putting aside the issue of fraud, is typically 6 years for ERISA claims. So ideally, you want to get a errors and omissions policy for the benefit of the transaction of the plan fiduciaries with a 6-year tail, or with a commitment by the company to maintain the policy in effect for 6 years. In any case, it's very important that the agreement of indemnification is between the company and the fiduciary, not the plan and the fiduciary, and that it's entered into prior to the transaction. And I think that as a matter of how valuations are performed, this is inherent in any valuation. But rather than let it be inherent, it might be a good idea to have the trustee's financial advisor make it explicit that one of the factors they're considering in reaching their opinion is the engagement letter of the trustee, including the provisions for indemnification of the trustee or whatever other plan fiduciaries we're talking about, so that the argument can be made that this was part of the determination of fair market value, and therefore it should not result in any further adjustment in order to be enforceable. Case study 4, and this is really the most difficult and perplexing problem. The misuse of company funds that I talked about a few minutes ago is something that really is pretty rare. Most of the ESOP companies that we have seen really are trying to do the right thing. They're not trying to take money away from plan participants or to abuse their positions. But you hire a team of professionals, you hire a trustee, you hire a financial advisor, you hire counsel, you think you've done your transaction right, and the economy changes, as we all know too well that it can and has. Say you were in the home building business or in a branch of technology for products that may be short-lived in their business cycle, although it wasn't apparent at the time of the transaction that they were short-lived. Or that you have a couple of large customers who may experience their own financial crises, such as bankruptcy, or simply cease to be customers unexpectedly. All of these events may result in sharp declines in the price, so that what may have looked like fair market value on the closing date looks far in excess of fair market value a few months or a couple of years later. Now, anyone who's been invested in the stock market knows full well that that happens. And in the stock market, well, let's take a moment and look back at what fair market value means. Fair market value is the price which a willing buyer will pay to a willing seller, each with full knowledge of relevant information and neither under any compulsion to buy or sell. Now, you can look right at this minute and see what the fair market value of Apple or IBM stock is, because we have a huge market of willing buyers and sellers, all with access to the same information, and none of them are under compulsion to buy or sell. It's much more difficult to determine fair market value in the case of an ESOP, where you're dealing with stock for which there is no market. And to compound that difficulty, the question of fair market value is always going to be judged in hindsight. Of course, when we're involved in the transaction, we don't have the luxury of knowing what's going to happen 2 years later. We use the best tools available to us to make our best guess at what that will be, and we base our conclusions and our actions upon that analysis. When the DOL comes along, they're in a much different frame of mind. They're looking backwards, and they see that you paid $10 million for this company, and today it's worth $1 million. I must say, and I'm not proud of my government for this statement, but I will limit it by acknowledging that it's a statement of one person who, when confronted with all of the good reasons that the closing date valuation was solid and ethical and proper and carefully done and was validated by a bank who lent money to the transaction, its own money, and by peer review of the valuation, that a DOL investigator said to me, well, you paid $10 million and it's worth $1 million. You must have done something wrong. Now, that's not sound reasoning, and it's not the law. And in that case, we have made it clear to the DOL that we're prepared to go to litigation. And thus far, they have not referred it to the solicitor's office. And in fact, that is the case I alluded to earlier, in which the solicitor's office, when presented those same arguments, said to me, not every case that gets referred to us actually goes to litigation. So there is both some darkness and some light in this analysis, but the key thing to remember is that this is judged in hindsight, that the valuations are complex, they are based on a lot of assumptions, and sometimes things go wrong despite everybody's best efforts. So how do you deal with this? At the time of the transaction, use an independent trustee so that if you are wrong, you have that level of independence. You don't have a conflict of interest between the trustee and the parties in interest. If you are the trustee, or even if you're, well, let me back up. If you are the trustee, you must evaluate the appraisal critically and rigorously. Most important, you have to pay particular attention to the information, such as the projections that are provided by the company. Often, that is the parties in interest. And keep records of your evaluation process so you can demonstrate what you did, because it's not enough to get to the right answer on the day of the closing. You have to be able to show 2 years later that you got to the right answer, because it may no longer appear to be so right. Involve the financial advisor who worked on the transaction in the investigation process. They have work papers, they have notes, they made the decisions of what discount rate to use and what level of growth projections to accept from the sellers. They did the investigation and they were involved in the due diligence to determine whether those projections were reasonable. Get them involved, keep them involved, talk to them, have them participate in the meeting with the DOL. Attempt to understand what the DOL is objecting to. And that's not always easy, because they don't have to tell you. If you agree with the DOL that a mistake was made, then it has to be rectified, and I'll discuss how to do that. If you cannot agree with the DOL investigator, and you've made every reasonable effort to explain the transaction value, be prepared to defend it. And that obviously is a cost and an aggravation and an effort that none of us want to incur, but it may be necessary, and if you've done a good job, you should prevail. If you agree that an error was made, assess the cost to the ESOP of the discrepancy between the actual purchase price or sale price. And I say or sale here because sometimes you're dealing with a situation where the ESOP sold stock back to the company or to an individual. Determine the difference, the discrepancy between the actual transaction price and adequate consideration. Add interest for the lost time value of the money, and have somebody make restitution to the ESOP. Ideally, the restitution should come from the seller if the seller received an excessive purchase price. The ESOP fiduciaries who agreed to the purchase may also be liable for any planned loss. And of course, with respect to that error and omissions policy that I advised you earlier should be in place, notify the carrier of a possible claim. One solution may be to provide a mechanism in the transaction document for adjusting the purchase price in the form of indemnification by the seller, excuse me. And if you've done this, you may be able to argue that no violation of ERISA occurred because the document, the agreement, is self-correcting. But of course, you can only make that argument if you do self-correct it. The Department of Labor has a couple of programs for correcting these problems. They are very specific in the scope of problem that can be solved and in the timing and method for correcting them. There is a voluntary fiduciary correction program. Excuse me, I think I got a slide out of order here. Okay, there's the VFCP, Voluntary Fiduciary Correction Program. There is the Delinquent Filer Voluntary Compliance Program for people who have not filed timely 5500s. Each of these plans is very specific in what it covers. You can conduct a fiduciary compliance review on your own initiation to avoid these problems arising and to prepare for them. It is 1:30. Our formal time is up. We've only got 2 or 3 slides left, so I'm going to continue. But if anyone has to drop off, I understand. If you'd like a copy of today's presentation, you can send an email to Alice Simons, ASIMONS, at sesadvisors.com. One way to avoid these problems is to conduct a compliance review before and hopefully without regard to any DOL investigation. A fiduciary compliance review includes the plan. If there is a problem, determine a self-fix course of action and set up an internal review process. Review your plan documents and interview personnel with respect to the plan. Prepare a work program based on these reviews and interviews. Prepare a report and recommendation, and then file and disclose under self-correction programs if that's practical and if it's required. Thank you all for your time. If there are any questions, I am going to stay on to answer them as long as you may want to ask them. If not, thank you all, and you can hear a recording of today's webcast on our website.
Bye.